I am Kim Carter of U.S. law member firm Kleindienst. In March 2020, Governor Newsom ordered a shelter in place in the state of California, making California the first state in the union that enacted such drastic measures for quarantines. When doing that, he also gave emergency power to Judicial Council and Chief Justice of the California Supreme Court to take emergency measures necessary to ensure that our courts continued to practice and stay open in light of this pandemic. Those emergency measures included things like remote depositions and electronic service of process, and the temporary suspension of civil jury trials. This also included a number of other measures that affected civil practice statewide. So what does that effect have on employment cases? Well, we've seen a number of different strategies that have now been employed by both defendants and plaintiffs that are now affecting how we practice employment law. For example, in the state of California, typically it takes about 1 to 1.5 years for a civil employment trial to take place in a case in federal court, and typically about 1.5 years for a trial to take place in state court. What we now anticipate, civil trials will not be proceeding in the state of California until maybe summer or fall of 2021. This will now take the life of an employment case and expand it to approximately 3 to 4 years. The trial date is what drives many of our employment practices, many of our negotiation strategies, and many of our discovery strategies. Now, with these extended trial dates, how do we get an employment case to resolution if the trial date is so far out, it's not actually affecting how parties engage in negotiation strategies? One of the first things that we're seeing is that settlements are becoming preeminent in employment law cases. Mediations are also being agreed to in a much higher rate than before. Plaintiffs' counsel and plaintiffs are largely motivated by wage replacement, and in many cases, plaintiffs are no longer employed, hence the need for employment cases in the first instance. In addition, we are seeing plaintiffs' counsel who are largely motivated by taking on employment cases for attorney fees provision, now looking at longer times to even obtain awards. So their cash flow and their ability to continue practice are also being affected. In some instances, we are seeing employers who are pleading poverty and that they're under dire financial circumstances. And as a result, there is a need for them to move the case or resolve the case as quick as possible. So mediations, alternative resolutions, and potential settlements are now largely motivated and leveraged by the current economic status, as opposed to the trial date being a motivating factor. Whereas the trial date being extended or unknown at this point in time does play a factor in the negotiation strategy. In addition, we are seeing an increase in arbitration requests. Plaintiffs tend to wish to pursue their actions in Superior Court, and employers tend to enforce arbitration provisions. Now, those roles have reversed. Plaintiffs are now more eager to move their matter through an arbitration process so that they can have their claims heard and a trier of fact or an arbitrator to decide those issues along with whether or not their attorneys get fee provisions. Whereas employers may weigh their options and may opt not to pursue the arbitration provision. So in all, what we're seeing in the employment arena is almost a complete switch to what we've seen in years before. So we're still playing chess. This is still a strategy game, and we're still waiting to see what the outcome will be. But for now, trials do not look like they're proceeding until sometime mid to late 2021. So I'm sure there's more to come. If you're ever in San Diego, feel free to check out our beautiful cave store in La Jolla Shores. It has a wonderful merchandise and a little hidden door that takes you right down underneath the cave into the alcove where you can overlook the Pacific Ocean. Thank you.